Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. A review of the docket today in the high-profile case of Gonzalez et al. Versus Washington State University reveals that there has not been any activity on the court docket since June 12th, approximately 5 weeks ago, when there were a couple of entries related to a transition concerning the court. This does not mean that the case is stalled, that there's nothing happening behind the scenes, for at least two reasons. First, there is a deadline coming up very soon that was instituted on June 1st when the court entered the order setting the trial, which is currently scheduled for September 13th, 2017, and all related pretrial deadlines and dates. The deadline for either of the sides to amend their pleading is coming up very soon, July 27th, 2026. What is this? This would be a situation if the plaintiff, for example, being that this case now has been active for a half year, might have learned additional details that might induce them to want to add additional claims against the defense, WSU, or perhaps drop a claim if they felt that the situation warranted it. The defense, same thing. They've been in litigation now for a half year, may have found some information that might induce the defense to want to add counterclaims against the plaintiffs. The deadline to do so is coming up in approximately 9 days. If that deadline comes and goes, and down the line, one or the other side wants to amend their complaint in the situation involving the plaintiffs, or the answer regarding the defense, they would have to show good cause why they missed this deadline regarding, for example, a motion for leave to amend a pleading. In such cases, the proposed amended complaint, the proposed amended answer would typically be attached as Exhibit A to show the court what the plaintiff's intending to do with respect to amending a pleading, or the defense. This matter is governed by Federal Rule Civil Procedure 15, and it states that a party may amend its pleading one time as a matter of course, no later than 21 days after serving it. That deadline has long come and gone. The complaint was filed in January. The answer was filed a month later. The rest of the rule indicates that in all other cases, a party may amend its pleading only with the opposing party's written consent or the court's leave. Leave means they would need to get permission from the court to do so. And it says here in the rule, again, this is Federal Civ Pro 15, the court should freely give leave when justice so requires. The second reason is that discovery has been underway in this case for quite some time. And there is a deadline, March 17th. Any discovery motions, if there's any motions to compel, for example, attendance at a deposition by one side who wants to depose the other side and they're having some difficulty in arranging for that deposition, or if answers to interrogatories, for example, are insufficient, vague, answers to discovery requests, answers to requests for admissions. These are all the discovery tools that are available in a federal lawsuit like this. They would need to go to the court, for example, to file a motion to compel. At this time, the parties are probably serving and responding to discovery. We will continue to keep you posted as further developments arise. Until next time, this is Kathy. Thank you very much for joining us here today.